Good day, everybody. This lecture is going to accompany Chapter 5 of the book. You may or may not want to pull up the PowerPoint to accompany the lecture, but I'm going to skip a lot of it because I don't really think it's that important in terms of legal research and writing. This chapter deals with primary sources of the law in terms of what you really think of as the law, which are statutes and things passed by the legislature and signed by a governor or the President of the United States. Okay. There are four primary sources of law, and I'll talk about them in a little more detail in a minute. And those are constitutions, statutes, court rules, and administrative law. Okay. Let's start with the Constitution, which is at the top. Okay. Remember from our previous discussions that the Constitution is the supreme law of the land. And no law, whether it's a state constitution, a local city ordinance, or any law, whether it's passed by Congress or not, or administrative regulation, can conflict with the United States Constitution. Okay. The Supreme Court decided in their most famous case, Marbury versus Madison, that they alone, or the federal courts in general, get to say what the Constitution means. Okay, so if you believe a law is unconstitutional, you can sometimes take it to state court, but more likely federal court, and then the federal courts will decide whether it's consistent with the Constitution, or if it's not, strike it down. I'm not going to get into the specifics of the Constitution or how to amend it or anything like that, because that's really better left for government class, and it's not something that's necessarily germane to legal research and writing. Now, every state also has their own constitution. When they become a state, one of the requirements is that the people in that particular territory draft a constitution. They submit it to Congress, and the Constitution does provide that each state have what they call a democratic form of government, so no dictators. They also can make, meaning Congress, can force states, if they want to become a state, or force territories if they want to become a state, to put specific things in there. Just to give you an example, when Utah became a state, or wanted to become a state, the Congress specifically said, in your Constitution, we want a provision outlawing polygamy. Okay, because some of the early Mormon settlers had more than one wife. There's still a small minority of Mormons that think polygamy is justified by the Bible and the Book of Mormon. So Congress specifically said, Utah, if you want to be a state, you got to put this in here. And that was fully within their rights. Okay, so state constitutions work like federal ones. The state is free to put additional things in there that are not in the federal constitution. As I've explained to you in the past, in the state of California's constitution, there is a right to privacy. As we know, the right to privacy has been created by the Supreme Court under the case of Griswold versus Connecticut, but there's nothing in the Constitution itself that inherently creates a right to privacy, as opposed to California, where we look, it's right in the Constitution itself. Every state in the United States, with the exception of Nebraska, is modeled on our federal government. Okay, there's an executive called the governor instead of a president, and there are two branches of the legislature. In Congress, we have the Senate and the House of Representatives. For example, in California, we have a Senate and we have an Assembly, okay, which functions like the House of Representatives in the federal government. Nebraska being the exception, where they only have one legislative body as opposed to two. Why? I don't know. Maybe they just want to save some money. You know, the less politicians, the better in my book. The next type of law is a statute. Okay, statute, as I've said in the past, is something that you would really think of as a law. Okay, under our system of government, both houses of the legislative branch have to pass it. then the president has to sign it or veto it. If it's a veto, there's a provision to override the veto. In the federal government, it's 2/3 of both houses. So good luck getting 2/3 of the senators and the House of Representatives to agree on something. Probably not going to happen these days. Okay. In California, it's actually likely that it can happen because the Democrats in California right now have what's known as a supermajority. They have enough members of both houses of the legislature to override Governor Jerry Brown's veto. They rarely do that, but they could do so. It might be interesting if we get a Republican governor to see, exactly how often they do that if in the next election we end up getting a Republican governor. Good luck with that one too, the way California's going. Okay, let's talk about how these laws actually become laws. Okay, a bill is introduced in the House or the Senate. I'm talking about the federal government, and then it goes to committee, and if it gets out of committee, then it goes to the floor for a vote. If it's passed, then it goes to the other chamber. They can accept it as it is, make a vote on it, or they can amend it, make some changes, and then normally what happens is the two houses get together in what's known as a conference committee and hash out the differences and send it back to both branches for vote. Okay. Then it goes off to the president or the governor to sign. So if it becomes law, then what happens is it becomes what's known as in the federal system a slip law. Okay, the slip law is just a little piece of paper that has the body of the law in it. Okay. It can be literally one page if they're maybe amending a statute already there, or it could be a 2,000-page document like the Patriot Act. So, or Obamacare, I think was like 2,000 pages or close to it. So they first come out literally as a pamphlet, and we call that a slip law. And it's given a number, and they're generally given numbers in chronological order, okay, which isn't really helpful for a researcher, because if we had to go look up laws based upon how they were chronologically passed, it would be a total pain in the ass. So what happens once it becomes a slip law is that actually there's a middle process where it becomes a session law, and they publish a book with all the laws from that particular session of Congress. Okay, a session of Congress lasts 2 years. So how do we find these laws if they're kind of published in such an inefficient manner? Okay, well, the legal publishers like Westlaw and LexisNexis create what they call codes. And what a code is it takes a law and it puts it in the context of which the law was passed, and it organizes the law by subject matter, so it becomes much easier to find. In the federal system, West's version of the laws of the United States is called the United States Code Annotated. And the Westlaw version, or the Lexis version, is called the United States Code Service. So it's USCA and USCS. Okay, and they're pretty much exactly the same in terms of where you would find them in the particular code. Okay, the codes are organized by subject matter. Okay, so if it has something to do with civil rights, or something that has to do with transportation, okay, there's specific codes, and in the federal system they're by number. Okay, so I don't want to look it up, but let's say code number 1 is traffic laws. So if I was looking for, I don't know, you have to stop at a red light. I'm just making this up. Maybe I would look at 1, which means volume 1, USCA, which means United States Code Annotated or United States Code Service, and then section, which is 1, which is the actual law number. Okay, so when you read a citation, first it'll tell you the volume number. Okay, then it'll tell you the type of code service, whether it's West or Lexus. And then it'll tell you the section number. So when you go to the index, or not the index, but the table of contents at the front, you can find it. So you pull it off the shelf, the particular code number or volume number, and then you look for that particular section number. Okay, so that's how we find things. Also, what the publishers like Lexus and Westlaw do is they create annotated codes. And what an annotated code does is, as opposed to an unannotated code, an unannotated code just has the law itself. Okay, now you might think that's great. It's actually really bad, because when you read the law, most of the time you don't understand what it means. At least I know. And so what the annotated code does is it gives you references to secondary materials that you can go and look at to help explain to you what the law means. And it also gives you cases that have been decided under that law, so you can look and see how courts have interpreted that particular code section. Okay, so most of the time when we do our legal research, we're looking at an annotated code, because usually by reading the law, that's not enough to get an understanding of it. Okay, so it'll refer us to secondary sources, and it'll refer us to actual cases decided under that law, interpreting it. You can see an example of that on page 144 of your book, where it says Chapter 119, Wire and Electronic Communications. Okay, you can see up at the top of the page there the section numbers. Okay, so this would be something to do with interception of oral communications. After the particular section numbers, or the table of contents there, if you look on page 145, it will have the actual secondary materials that you might want to look at for a particular code section. Now, how would I know what I'm looking at? Okay, well, if I look up at the very left-hand top of the page there, there's 18. That lets me know it's code number 18. And then the section number 2519. Okay, so I know I'm in volume 18, and I'm reading law or section number 2519. Okay, it'll normally start off with some legislative history, whether this is a new law, whether it's amending an old law, and things like that. Okay. Below that, under the library references, if you look, there's a little key number there. Okay, if you're in the West system, you can use that key number to jump directly to cases. And it also gives you some texts and treaties, law review treatment, and secondary materials that you can go and consult to try to figure out what the heck it means. Okay, down at the bottom of the page, we see a new law, which is section 2520. Okay, that's down at the bottom of 145, and then we could go and read that law. And going on to the next page, there's the complete statute itself. Okay, below that are the historical notes. There's a citation on 147 to American Law Reports. There are the good old library references, and then when we get below that, actually strike that. I'm sorry, I don't want to redo this. Go back to page 145, and you can see there the notes of decisions under the 2519 law. Okay, 1, failure to file. Okay, that is a court case. If I look at it, it says U.S. versus Kone, and that is a little what we call blurb. And it says, failure to file reports with Administrative Office of the United States Court was not a ground for suppression of evidence obtained by court authorized wiretaps. So if that was the issue in this case, I'd go find that case and read it. Okay, there can literally be hundreds and hundreds and hundreds of cases decided under a particular law. Okay, so just because you see one here doesn't think that's the norm. Unless it's a very, very new law, the norm is the notes of decision will have hundreds of cases to look at. Okay. So that's kind of the gist of the how a statute works. Okay. If you want to look on page 148, there's a notes of decisions. Okay, and that's what I was talking about in terms of the laws. Okay, for example, if I look at that, and I'm on page 148, if I look at my issue with sale of wiretapping devices, I would go to keynote number 10 under this law, and I could read the little one sentence or two sentence blurb or summary of what Westlaw thinks that case is about. Okay. If it was about defenses to this particular law, I could look there under defenses and see that there maybe the issue is good faith or ignorance of the law or mistake of the law. And those little numbers there, 13, 14, 15, 16, are the key numbers that I could jump directly to read about cases about, let's say, the defense of mistake of law. To see more notes of decisions, you can go to page 154 at the bottom, and there's some more sample notes of decision regarding this particular federal law. Okay, so a lot of times there can be all kinds of secondary stuff. There can be all kinds of legislative history and cases decided under the law. Let's talk about state law. Okay, I'm going to talk obviously about California because that's what I know. Okay, California also has a codified system. Okay, there's a West version of the California laws, and there's a LexisNexis version of the California laws. Okay, there are two separate, annotated codes. Okay, the main difference between California law and state law in terms of the codes is that the codes in California are arranged by a name as opposed to a number. Okay, so in California we don't have volume 1 and volume 12 and volume 19 in the federal system, which deals with civil rights. Okay, what we have is codes by name. Okay, so there's the Business and Professions Code. There's the Civil Code. There's the Code of Civil Procedure. There's the Insurance Code. Okay, so we don't organize things and cite things by number. We cite them by name. For example, Civil Code, or let's say I have an issue on discovery. And when I cite it to the court, it'll be Code of Civil Procedure section 218. Okay, and we have little abbreviations, and we'll get into citation later on in the course. But we don't use that like 11 USC or USC annotated section 590. In California, it's just we name the code, Family Code section 2020, whatever it is. And so that's the main difference between California and federal in terms of how they're organized. Okay, California names, federal court by number. Okay, in all other respects, they're pretty much the same. The next type of laws are local laws. Okay, what can these be? Well, in Kern County here, we have a board of supervisors, and they can pass laws that are, as long as they're not inconsistent with the state of California and the laws of the state of California or the Constitution. So a local law, whether it's a law by a city, like the city of Bakersfield, or a county, cannot contradict a state law, okay, because they're kind of like the court system. There's a hierarchy, and so the Constitution is the president, the state laws are like the generals, and so you can't pass a law or make a rule at the local level that contradicts a state law or its constitution. So local laws can be passed. The way it works here in Kern County is we have a county board of supervisors, and they're elected by their particular districts, and they're free to pass whatever laws they think benefit the people of Kern County. At the city level, we have the city of Bakersfield, and the city of Bakersfield passes laws, but they're only they're limited to the jurisdictional limits of the city of Bakersfield. Okay, so for example, if the law of the city of Bakersfield is you have to have a dog on a leash, but there's no county law that says that, well, If you're outside the city limits, that isn't enforceable. And it makes it kind of really confusing in Bakersfield because there's actually parts of the city, if you pull up a city map, like the neighborhood I grew up in, which is just north of Valley Plaza, there's actually part of the county, even though it's in the middle of the frickin' city. Another example is Union Avenue. One side of Union Avenue is actually in the city, and the other side is in the county. Okay, so that's how kind of crazy it is. Okay, but the point being that a city government can only pass laws that are valid within the city limits. Okay, most county governments don't have an executive like a mayor or governor or anything like that. Bakersfield does have a mayor, but the mayor is really a figurehead. The only time the mayor has any power in the city of Bakersfield is to vote on a tie between the members of the city council. Okay, so if there's a tie, he gets to break the tie. Other than that, the mayor of Bakersfield really doesn't run the city. That's done by the city manager. And that's the way the county is too. The county hires professional employees to kind of be the executive and run the county on their behalf. Another type of law you need to be aware of, particularly if you're going to get into being a litigator, or work for a litigator, so to speak, are the court rules. Okay, there are not only state court rules. Okay, the rules of court in California are governed at the highest level by the Code of Civil Procedure. At the next level, we have the California Rules of Court, and the California Rules of Court are really promulgated by the California Supreme Court. And then they decide what they think the law is, and the legislature usually gives its okay to the rules of court. They're obviously more in detail. And then also, we have local rules. Okay, so each county, like I work now for the county of Kern, the Superior Court County of Kern, your paperwork or whatever has to conform to the local rules of the particular court that you're in too. So don't ever forget, like, I always had a copy. I went down, photocopied a copy of the local rules and had it in my office. Okay, don't forget about the local rules of the particular court. Okay, at the federal level, they have the federal, civil procedure rules, and then they also have the federal rules of court. Okay, it's very similar to the California. It's just the terminology is just a little bit different. Okay, but don't think the law is the same, because in terms of the rules of civil procedure in California court and federal courts, they're actually in a lot of cases very, very different. So if you have issues on procedure or court rules, don't ever assume that if you're looking at a federal rule that it's the same in California, because it's probably not. In the federal system, they have the Federal Rules of Civil Procedure, and they have a separate set for criminal procedure. It's actually a different set of laws that governs criminal trials versus civil trials for very different reasons. They also have the Federal Rules of Evidence as well. Okay. Similar in the California system, we have an evidence code. We have the rules of civil procedure, and we have rules of criminal procedure as well. The last set of laws that we need to deal with in this section are administrative laws, or what we call administrative regulations. Okay, the way administrative regulations work is a little bit different. I'm not going to make you research administrative law because it's kind of a pain in the ass, but I'm going to make you aware of how it gets to become law, because that's important. Okay. Normally, the way in administrative law, administrative agencies are actually part of the executive branch. Okay. So whether it's the Environmental Protection Agency at the federal level, or the Department of Transportation here in California, whatever it might be, the head of an administrative agency is the governor. Okay, so how do the laws get passed? Well, this is what happens normally, is Congress creates a new set of laws. And they don't have time to get into all the nitty-gritty details. So this is what they do. They create an administrative agency, like OSHA, and then they delegate their power to make law to the administrative agency. And the administrative agency is free to make the laws that they want, what we call administrative regulations, as long as they're not inconsistent with the overall scheme of the law that's been set up by Congress. Okay. And in the federal system, and also to an extent in the state of California, there are many, many more administrative regulations than there are actual statutes. Okay. Like I said, the government is free to, or the legislature is free to change those if they don't like those rules. The courts are free to strike them down if they think they're inconsistent with the overall legislative scheme and statutes, or inconsistent with the Constitution of the United States. Those laws or those regulations are published in the federal system in what we call, first they're chronologically published in the Federal Register, and then they get codified just like regular statutes do in the Code of Federal Regulations. California is similar. Okay, we have the California Code of Regulations, okay, as well. And the thing about regulations is, when you're finding a regulation and you're trying to interpret it, one of the bummers that may either hurt your client or help your client is there's a lot fewer court decisions interpreting administrative regulations versus statutes themselves. Okay. The reason is a lot of times these cases are heard by administrative agencies and they don't necessarily publish opinions like the court systems do. Other reasons are that they pass so many laws. A lot of times courts haven't even passed, or there hasn't been any litigation regarding the interpretation or the application of that particular regulation to a set of facts. So, but they are set up in the same way, which means the Federal Code of Regulations and the California Code of Regulations is annotated, which means if there are particular cases that have been cited under that particular regulation, they will appear in the annotated codes. You're generally going to find a lot more law and a lot less cases in the codes of regulation, those annotated codes. That's the end of this week's lecture. We only have three more chapters to cover. We're going to cover chapters 5, 6, and 7. But don't worry, I'll have plenty of things to do. One of the problems in teaching this class is that you kind of have to throw everything out there, and it's not going to make a lot of sense. So what I'm going to try to do over the next few weeks is, one, reinforce some of these concepts, and see if I can also tie all this stuff together so it makes some more sense to you. So if you feel like you're still kind of a little lost at sea, don't worry. I'll do my best to kind of put everything, once we get it out there, in context. And remember, you're always free to email me or pick up the phone. So you guys have a great week. I'm over now.